What's up, everybody? Welcome back into another episode of The Lawyer You Know. We still don't have a jury in the Karen Read case, but I believe opening statements are going to be at least some point this week, probably midweek now. A few motions were filed today that you guys had questions on. How are they going to be able to use Karen Read statements? Will they use them? The Gretchen Voss motion. How is all that going to work? Don't they have to authenticate them? Aren't there rules? Aren't there things they have to do? We're going to talk about that, answer questions. And then I've had so many questions in different ways about what would you do? What would you do different? What would you do in this trial versus the first trial? How would you give some kind of opening statement? So I'll give you some kind of an outline basically of if I was going into this case, how simple would I make an opening statement? And we're going to kind of go through that in the second half of this video. And of course, answer as many of your questions as we can. So let's get to it. All right, so we're going to start out with these motions, and we got to get into, our fight and form here with the nightly videos, get back used to that because it's been the afternoon lives for a while. So all reports say that they lost a juror today, got a juror today, so they're still at 16. They're still trying to get two more. Hopefully that happens at some point tomorrow. If it does, maybe we get opening statements tomorrow. If it doesn't, maybe we'll get opening statements by Wednesday. We will just continue to follow along with all of the reports. But let's take a look at a couple quick motions today. The first one is the Commonwealth's notice of intention to introduce extrajudicial statements of the defendant. Now comes the Commonwealth in the above captioned matter and indicates its intention to introduce relevant statements of the defendant either without a witness or through a non-percipient witness reader. Under Massachusetts law, statements of a party opponent are admissible in evidence to prove the truth of the matter admitted in them. Any extrajudicial statement by a party may be admitted in evidence against him by opponent and will not be excluded on grounds that it constitutes hearsay. The hearsay exception of the party opponent encompasses any extrajudicial statement made by a party opponent, not just statements that are inculpatory or against the party's interest. So yes, in civil cases, criminal cases, party opponent statements are always going to be admissible, almost always going to be admissible. We knew that was why it's such a big deal that Karen Read went out, made these statements in interviews. That's why you usually don't want to do this. That's why most criminal defendants don't. No surprise there. To admit a statement of a party opponent, there is no requirement that a foundation be laid, nor a witness that has personal knowledge of the subject. Text messages sent from the defendant to the victim were admissible under the hearsay exception for a party opponent statement and properly admitted to provide important context for the defendant's text message. Text message to defendant properly admitted to provide necessary context to defendant's admissible statements. The defendant has made numerous statements to witnesses, first responders, medical providers, family members, and journalists, as well as recorded statements on John O'Keefe's cell phone. These statements range from the defendant's immediate impressions and state of mind in the minutes and hours surrounding John O'Keefe's death to crafted narrations, sometimes in the presence of counsel, that recount for the defendant's version of impressions of events months and years after the murder. All of these statements are ones of the opposing party made by the defendant and therefore admissible. The Commonwealth thereby provides its honorable court notice of its intention to introduce statements of the defendant and can provide the court copies in advance for any preliminary findings of fact that it was the defendant who made the statements. The Commonwealth also moves to provide notice that it intends to introduce the defendant's own statements without a witness or in some circumstances through a non-percipient witness reader, which would mean somebody just gets on the stand and reads as Karen Read. So most of the questions surrounding this were, how is this possible? How can they just enter these in? How do they not have to, call a witness? How do they not have to have a records custodian? Doesn't this have to be stipulated to? So a few things that I'll mention here. Generally, party opponent defendant's statements are admissible. But if the defendant says, that's not me, if the defendant says that's taken out of context, if the defendant says you've got to use the whole transcript or you've got to use the whole text message, they have issues with individual statements, there can still be a fight. So while the statements are generally admissible, it doesn't mean that they just automatically come in. There has to be some kind of stipulation. There has to be somebody that says that's the defendant, that's Karen Read. There has to be somebody that says that's her phone number. We got it from her phone extraction. That's a text message from her. So they're still going to have to lay the proper foundation unless it is stipulated to. Unless it is stipulated to. Ashley asked, whoops, that's the wrong one. Chat's going a little quick. Does the Commonwealth have to provide the specific statements ahead of time to the defense? So usually the answer is yes. What are you going to enter? You can't just say we're going to enter whatever we want. What are you going to enter? When are you going to enter it? If it's a transcript, we maybe need these parts to add context. It's totally unfair if you say this and not that. So yes, usually you do have to put the other side on notice what statements you are actually going to use. And as far as what stipulations are made, we don't necessarily know what stipulations are made, but there was another filing that we're going to read, and it is the unopposed motion of Gretchen Voss for exclusion from the sequestration order, meaning she wants to sit in the trial even though she is a potential witness because the witnesses are excluded from the courtroom. Third-party journalist Gretchen Voss respectfully moves for an order excluding her from the provisions of the witness sequestration order. In this case, counsel for both the Commonwealth and the defendant have indicated they do not oppose this motion. That's interesting. As grounds for a motion, Voss states that one, the Commonwealth and the defendant have agreed that Voss will not be called as a witness at trial. So why would Gretchen Voss be called as a witness? Well, if the defense forced the Commonwealth to authenticate that Karen Read was the one making these statements, that Karen Read was the one giving the interview, that she didn't force Karen Read to say any of this stuff, that it's not taken out of context, well, then you might need Gretchen Voss to identify all of that or authenticate all of that. If you're agreeing to it, which again, if you're the defendant, what's the point of saying I don't agree to it, right? Like, what's the point of saying, no, that's not Karen Read? Everybody knows it's Karen Read. You knew this was going to happen when you did the interviews. That's why I think there are a lot of stipulations around this that maybe we don't know about yet. Number two, enforcing the sequestration order against Voss would violate her First Amendment rights. Gretchen Voss, a contributing editor for Boston Magazine, has been covering the case since its inception. She reported and wrote the story, The Killing That Tore a Town Apart, which was published in October of 23. She has continued her reporting on the court proceedings since then for future coverage of the case, whether for Boston or another media outlet. She was not a party or a witness to any criminal activity. Rather, her connection to the case is only from her accurate reporting of news to the Republic. In response, by the way, this is Gretchen Voss writing this. So in response to the Commonwealth, or her lawyers, I should say, Commonwealth's renewed motion for records and as ordered by the court, Voss turned over the audio recordings of the two on the record interviews she conducted with defendant Read and her counsel. It is her understanding that the Commonwealth intends to use portions of those recordings at trial. Although Voss's name originally appeared on the Commonwealth's prospective witness list, counsel for both the Commonwealth and defendant have informed undersigned counsel that Voss will not, in fact, be called as a witness. Instead, the Commonwealth and the defendant intend, so it means they haven't yet, to stipulate as to the authenticity of the records produced by Voss, thereby rendering Voss's testimony unnecessary. By virtue of the Commonwealth's random selection process, Voss has been approved to attend and report on the trial of this case. Prohibiting her from doing so and enforcing the sequestration order against her would threaten the public's understanding of events occurring at trial and unnecessarily interfere with the free flow of information. There can be no question she has a First Amendment right to attend the trial and to do the same as other members of the press. Only in the most extraordinary circumstances is the government permitted, consistent with the First Amendment, to discriminate among members of the press in granting access to trials and other governmental proceedings. Exclusions from the sequestration orders are commonly granted, particularly from non-adversarial witnesses. Given the stipulation to which the Commonwealth and defendant have agreed, and in view of the exceedingly narrow scope of any relevant testimony Voss might offer, the public interest in her being able to cover this proceeding far outweighs any conceivable interest in excluding her from trial. Meaning, okay, let's say the worst happens and she sits through the trial and they decide not to stipulate and they do have to call her. Whatever anybody else says is not going to affect her testimony. It's not like she's going to testify to what she saw outside 34 Fairview, how fast Karen Read was going, how many drinks she had. She's not testifying to any of that. She's just going to testify to the interview, and nobody's really going to affect her testimony about what happened in that interview. So no big deal, no harm, no foul, even if they do have to end up calling her. As was also true in Connolly, allowance of this motion has the salutary effect of permitting Voss to meet her important First Amendment responsibility of keeping the public informed as to the events taking place in open court. For the above reasons, Voss requests the court enter an order excluding her from the witness sequestration order. In this case, I expect Judge Cannoni to grant this and allow Gretchen Voss to sit in during this trial. Okay, so that's basically what happened. That was most of your questions. I don't believe anything the Commonwealth says. I stipulate to nothing. Tracy, I think that they are going to do a lot of that, but I don't think the defense wants to waste time either. So it's like, are you really going to say that's not Karen Read in those interviews? It's one thing to make sure that they're all taken within context, that you can explain them all if you're the defense. But I mean, from my perspective, in reality, I don't think this was that big of a give by the defense. Zeselak said, are the jurors already selected just sitting in the courthouse waiting for opening statements, or do they wait at home and wait to be called in? I don't know how they do it there, because I've heard somebody that was a juror before was brought back in and questioned again. So I don't know if that happens every day or if they specifically call certain jurors back. What do you think the odds are that a lie unchecked becomes the truth, makes it into the opening statement? I have it on my proverbial bingo card for the defense opening. I don't know. But I have thought about this a little bit, right? And before I go into like how I would do an opening statement in this case, I think it's important to mention a couple things. Number one, I think she has great lawyers. They're going to do a much better job than I do. They know this case way better than I do. They've been handling it. Dog Lover said, you talk so fast. I'll slow down when we get to the opening statement. A lot of times when I'm reading documents, I don't want to bore people. So I just kind of read through them quickly and give the analysis. But as far as it goes with the opening statement, this is just from my perspective. When I try cases and a lot's going on, and okay, relax, everybody, relax. If I'm talking too fast, guess what? There's a little thing you can click on YouTube to slow me down, and you can listen to me at your listening pleasure and exactly how fast or slow you'd like to listen to me. But anyways, as far as this opening statement goes, I have been trying to think about like how I would simplify it, because no matter what you do in the time constraints that they have, you're not going to be able to hit on every single thing. That's what the trial is for. You have the opportunity in opening to highlight what you want the jury to look out for. Of course, what you think the evidence is going to show or what it's not going to show. A little bit of argument mixed in. It's supposed to be mostly what the evidence is going to show, but a little bit of argument's usually okay. Even if it gets objected to, you can work around it and just present what the evidence will show if the judge is shutting you down or holding it tight. But it's, from my perspective, highlight a couple of the most important points that maybe will shock the jury a little bit, will keep the jury on their toes, will keep the jury from just going all in and believing every single thing that every Commonwealth witness has to say. And from my perspective, that is the most important thing to do in opening statements. And then in closing arguments, it is to arm the jury with things that can go back there and say, no, but this, but this, but this. And the jurors that are with you will go back and argue for your side. For anybody that disagrees with it, pull them on your side, not be able to go onto the other side, things like that. Okay. From my perspective, that's usually how I look at opening and closing. So for opening, you want to give a roadmap of the really good evidence for you that's going to show the case in a way that you want it to be showed. I would like to use some text messages. I would like to use some video. I would like to use some audio. I would like to use documents. I would like to use witness names, exactly what you can expect to hear and see. And I like to do it in a way that I'm absolutely confident is exactly how the evidence is going to come out. And that's also why the whole conspiracy and third-party culprit and putting too much on that, from my perspective, is a risk, because it may not come out the way that you think it will. Maybe they'll feel bad for those third-party culprits. Maybe they'll feel bad for the witness intimidation allegations if those come out in trial. And then it can really kind of mess up what you went with an opening. And you have to be careful not to burden shift and put the burden on you. So all those things are in your head as a lawyer. There's no perfect opening. There's no perfect closing. Anybody can Monday morning quarterback it, including myself, and say, oh, I would have done this. Oh, I would have done that. But we have discussed this a lot on this channel. And most of you guys watching this right now, hit the like button if you haven't already, because a lot of you asked for this. I've kind of been hesitant to do it. And also, if you guys want me to do an opening statement for the Commonwealth, I will do that as well. I think it will be difficult, honestly. This would potentially be the most difficult Commonwealth opening statement for me to do, or prosecution opening statement. Usually they're a lot easier than the defense's opening statement or closing argument. But if you guys want to, I will do that as well, because I do videos that are requested. That's kind of what I build my whole channel around. What you guys want to see and hear is what I try to do. So from my perspective, when we're doing an opening statement for the defense, I am going to try to highlight the most important things, almost like an appeal. I'm not going to be able to hit everything. I'm not going to be able to talk about every witness. I'm not going to be able to talk about every problem in the Commonwealth's case, right? And I'll indicate things like that, like to the jury, this isn't it. This is just what I can fit in my opening statement, basically. Okay, so you always have to have a theme, and I think this matters with what happens in jury selection, which I don't know as well. I like to work jury selection into my opening statements, usually because, you know, some inside jokes, kind of, maybe not jokes, but inside comments with the jury, like, oh, remember when we talked about this in jury selection, things like that, draw from that. But for this specific case, I think my theme would be just like the criminal justice system, period, and how important that is. And start out something like, welcome to the criminal justice system. You guys are about to get your crash course here. It isn't perfect, but it's the best in the world in my estimation. And I would define and say, I'll just kind of give it as a speech now, as opposed to kind of telling you what I'm doing. But if you guys have questions, I can stop in the middle and we can talk about it. But a system is a set of interconnected parts that work together as a whole to achieve a specific purpose or function. And the criminal justice system is just that. It is interconnected parts that have to work together or the system fails. And the parts of a system can be physical, can be conceptual, like theories, or it can even be people. And if any part of that system is broken and the system fails, then it doesn't achieve its intended purpose or function. And I would mention something like in jury selection, we hammered reasonable doubt. We hammered the presumption of innocence. These are key aspects to the criminal justice system. These are key parts that without them, it just doesn't work. Beyond a reasonable doubt is the highest burden in the land. It's the highest burden in our entire country for any case that exists. It's very different than civil burdens. This is not a case here where you're supposed to figure out what's more likely than not, what might have happened, what possibly happened. You're supposed to look at what the evidence showed happen in this case. And the burden lays with the Commonwealth fully. They have the burden to prove this case beyond a reasonable doubt. We have no burden. We don't have to do anything. We don't have to poke holes. We don't have to create reasonable doubt. The Commonwealth has to prove this case beyond a reasonable doubt, and they have to do it with the evidence that comes out in the case. So what will the evidence show in this case? Well, you're going to hear that the prosecution team does not just include these lawyers over here, but also law enforcement. And what law enforcement did starting January 29, 2022 is a huge part of this case. It's a huge part of our system. And if law enforcement is broken, then clearly the criminal justice system does not work. They are part of the interconnected parts that make the system. And the evidence will show that we will never know what happened on January 29th, 2022 because of what law enforcement did and didn't do. They will admit to you on the stand through evidence. That's evidence right there, the witness stand. And you point to the witness stand and you say, what you're going to hear from there is that law enforcement did not follow their own protocols. They have protocols set up for their systems. They have systems that create a purpose, and that's a good investigation that creates a just outcome. They will tell you that from the stand. That's not argument, right? Can't get objected to that because that's exactly what they'll say. And yet they violated their own systems over and over and over again. And they'll even admit that it was regrettable and they shouldn't have done it. So I'm going to mention a few, but there will be so much more as we go throughout the trial that you'll hear from their witness stand. One of the most important parts of this case and every case is witnesses, interviews. And they are supposed to record their interviews. They are supposed to record every bit of those interviews so that there's no inconsistencies. So we're not relying on written statements, on what one witness saying, nope, that's not what I told law enforcement, and law enforcement getting up and saying, yep, that's what a witness told me. You're going to hear that over and over again in this case. And you're going to see errors and inconsistencies throughout the written documents and the written explanations of what happened in interviews because they failed to record the interviews, which is their own policy. Investigating all leads, also their own policy, and they failed to investigate lead after lead. You're going to hear that a body was found on the lawn of 34 Fairview, and they didn't even knock on the door. They didn't talk to a single person inside that night. They didn't ask any questions. They didn't go inside to see if there was any evidence inside. They didn't go inside to see if there were any other victims inside. They did nothing. They didn't investigate tons of leads that they should have, that we would maybe know what happened that night if they would have, but they didn't. So we don't. And that is a broken part of this system. Therefore, it can't produce the just result in this case. They're also, another one of their policies is to produce and secure all relevant evidence. And yet they failed to do this over and over again, whether it's a broken taillight that they said they found piece after piece after piece, day after day, week after week, even though they sent teams out there to look for them. Whether it is surveillance video and cameras, and I would show the inverted camera. This is clearly inverted. I would show a blurry camera. I would show breaks and cuts in the camera and say, this is the type of evidence that they failed to secure. They failed to protect. They failed to turn over. And because of this, because this is also damaged, it's basically unusable. And with unusable evidence, you really can't prove anything. And if you can't prove anything, the system doesn't work. And then the tools that they use, instead of crime scene kits, instead of doing everything by the book and securing the crime scene and taping it off and having only officers there, they used red Solo cups. And you make a big deal about the red Solo cups. The red Solo cups that they use to gather evidence, gather blood. Seriously, yes, that's what happened in this case. The Stop and Shop bags, the leaf blower. I mean, you could have a heyday in opening statement as a lawyer with those things, and that should, and I think will, shock a jury. That's how this investigation was done, clearly violating their own protocol, their own systems that they have in place to make sure they get the right result. And then you talk about how it'll show so many more errors. And you say, members of the jury, you may ask why. Why did this happen? Well, there are a few possible reasons that the evidence will show. First, it could be pure negligence. They'll admit to you, some of them didn't know what they were doing. They didn't have the proper tools. They didn't have the proper training. They didn't know who should be conflicted off this case and who shouldn't be conflicted off this case. There was so much they didn't know, so much they didn't do right, and it could just be pure negligence, which still the system fails. It can be intentionally avoiding investigating a cop. And then I would show the text messages about how it's a Boston cop and we're not going to mess with him. And let's just, it's easier to pin it on the girl, or make sure you're getting your stories straight with the group chats. Karen Reed is an outsider, an easy target. You can go through all that. And how, whether there's a conspiracy or not, they clearly avoided investigating a cop. They didn't want any blowback. They were protecting each other, the thin blue line, et cetera, et cetera. That's where you can make that argument. And then when you talk about cops protecting cops, you can go to the third possible reason, and that's just bad cops. Bad cops. The worst kind. You'll hear about cops drinking and driving, drinking the night of the incident and going to the police station to handle admin work when they're admittedly drunk. Cameras showing them on the phone, maybe show some phone records where they will literally say they were butt dialing each other. Cops that destroy their phones and get rid of them on military bases. Those kind of cops. Cops that lose firearms after a night of drinking and don't know where they are. Those kind of cops. But they saved the worst for the lead investigator. And that's when you clearly read Michael Proctor's texts. Here's what he had to say: objectifying Karen Reed, making fun of her medical issues, wanting to pin it on her immediately and never looking back, demeans her because of the way she speaks, the way that she looks. And then, of course, when he's alone, whatever language Jackson or Yannetti used, alone with no one watching, he's searching her phone for nudes and talking about it with his buddies and fellow cops. Those are the kind of cops we have in this case. So when you ask why, the evidence will show it was either negligence, intentional avoidance of investigating a cop, or just the fact that we have bad cops in this case, which break the system and prevent the opportunity to get the result the system is intended to get. That's the type of the investigation you'll see here. So that's basically the first big chunk of opening. And from my perspective, I am incredibly confident the defense will be able to bring all that out in evidence. I think that each and every one of those facts are going to come out. Cops have to admit. Oh, and I would also say, I got Trooper Paul coming up, but these cops are going to have to admit that they screwed up the investigation. They're going to have to admit it sucks. They're going to have to admit you shouldn't use red Solo cups, that's against policy. They're going to have to admit they should record interviews. They're going to have to admit that they shouldn't use the Stop and Shop bag. They're going to have to admit that members of the CERT team that came out and searched with them, they don't even know if they're cops or not. They don't even know who those people are. They can't even tell you. That's the type of investigation we're dealing with in the criminal justice system to prove it in the highest burden in all the land, right? So that's why I focus on that. I think simply speaking, that is almost guaranteed to come out in a way that will be good for the defense. And then, of course, you talk about the fact that they didn't interview a lot of witnesses until months and years later. And there's just so much more you could add in there, of course, but you get the gist. And then the second part, I would say, at the end of the day, the defense or the Commonwealth has to prove beyond a reasonable doubt that John O'Keefe was hit by a car to convict Karen Reed of anything in this case. And the evidence that will come out from experts in this case with these resumes, and I think I would put Russell's resume and Arca's resumes up on the whiteboard, the PowerPoint, whatever you're allowed to do. I don't know what Judge Cannoni's rules are going to be. But I would put it up here just how experienced these people are, just how great these resumes are. These are the experts that are going to testify to you that it is totally unreasonable to believe that John O'Keefe was ever hit by a car. This doctor with all this ER experience reached out because she wanted to help when she heard about this case. So we hired her because we saw her years of experience. And she said, after treating thousands of patients in the ER and as a medical examiner, so many of them dealing with car accidents, this is not an injury that you would sustain from getting hit by a car as a pedestrian. She'll say it's more likely some kind of dog injury. And guess what? The owners of 34 Fairview had a dog. But guess what? That dog wasn't looked into. The house wasn't looked into, wasn't investigated. And that dog and that house were also, the owners got rid of both of them shortly after this incident. Reasonable doubt because of a failed investigation. But then we get to the science and the math with these ARCA witnesses. And again, you put their resumes up there so they can see that this is exactly what they do. And let me tell you about ARCA. Well, these witnesses were, and I would kind of say something like, you know, a tail light on a Lexus this size can't make those marks on John O'Keefe's arms, and you show that. They can't leave his body where it laid with the injuries that he had. If he was hit by a car and he ended up here, he would have internal bleeding, bruising, broken bones, you know, all of kind of the logical common sense stuff. The math just won't math. It's not adding up. And that's exactly what these ARCA witnesses will tell you. But what's incredibly interesting about these ARCA witnesses is they were paid to do their testing and investigation and give their opinion that they're going to give you today by a third party completely independent of this case, of Karen Reed, of the Commonwealth, a third party that wasn't looking to help Karen Reed in any way, shape, or form, didn't know who Karen Reed was. They didn't know who they were doing any of this investigation for as far as who drove the Lexus or who John O'Keefe was. The Commonwealth will tell you that we paid them. But the truth is, and what you're going to hear the experts say, the only thing we ever paid them to do was fly here and testify from that chair. They were paid by somebody completely disconnected from Karen Reed that wasn't looking to help Karen Reed to do all of their testing and come up with their opinion completely. Ashley said, isn't that argument? So I don't know what part you're talking about, but if you're talking about argument, I mean, if you're talking about ARCA, absolutely not. This is all going to come out in evidence because I'm going to ask ARCA all these questions. Was the person that paid you trying to help Karen Reed? Did Karen Reed hire him? Did Karen Reed pay you through them? Did Karen Reed have anything to do? Did she tell you how to, or did we tell you how to do the testing? Did we ask you what you wanted for your opinion, or did somebody else? All we did was pay you to do X, Y, and Z. That's how I believe it's going to come out in evidence from my perspective. So I don't think that's argument. Now, there's definitely some things in this opening statement that you could say are argument. So from my perspective, you focus on the investigation, the horrible investigation, the bad cops, and Dr. Russell and the ARCA witnesses. And then again, you wind it up with the evidence will show that the investigation sucked, basically. The evidence will show that these are bad cops, and the evidence will show that John O'Keefe was never hit by a car. So the only just result you'll be able to come up with after you listen to all the evidence is not guilty, because we can't break our criminal justice system. So Lady Los Angeles said, is it really that important who hired him? To me, it is, right? To me, it is. I don't think it's the end all be all. I think they can still be reliable if they were defense experts. Obviously, that happens in every single case, that the defense hire experts and they still can be reliable. So from my perspective, that's what I would focus on, right? They'll do a much better job. They know the case way better than I do. They'll delve into a lot of the more details. They'll have a lot more exhibits and evidence to be able to show if they want to, if Judge Cannoni allows it. But those are kind of the main points I would focus on. The investigation, the cops, what they did, what they said, what they didn't do, what types of cops these are, some of the things you can impeach them in, and just so many of the things that when you first hear them, it makes you say, That's my problem, is I would want to highlight I wouldn't want to highlight like, okay, McCabe is married to this person who's connected to this person who's connected to that person. If I want to get into that in the trial, you can, and you mention it by them intentionally avoiding even investigating a cop, right? You hit that, but you don't necessarily have to give all of that in your opening statement to me. Kansas says, I don't understand why they can't just know of the FBI involvement because it would be prejudicial, more prejudicial than probative. What does it actually prove that the FBI hired them versus how prejudicial it would be? That's from the judge's perspective and the rules of evidence. The rural juror. It would be such sweet, sweet irony for Jackson to use Brennan's righteous indignation in his opening. I'm sure there's going to be a lot of that. I have to correct the record. My attempt last week was not clear. I provided incorrect info to Peter. He passed that info along to the chat. This was solely my fault. Peter, am I off probation now? You are cleared. You are cleared, my friend. John said you can technically over highlight something. I agree. But I think if you plant enough seeds in the jury's head that this investigation sucked, can we say beyond a reasonable doubt that she did this if we know how bad this investigation sucked? That's kind of, from my perspective, what I would want people to think. That's what I would want them to think if I was the lawyer on the case. And I have some thoughts about what I would say as far as best evidence with as the Commonwealth. A lot of it would probably be Karen Reed's own statements and, trying to use them against her as best as I could if I was the Commonwealth, which, again, I've already said, I would not prosecute this case if I was the prosecutor on it. I would drop these charges. Terry, AJ said strategy would change if 1 and 3 dropped. What if Commonwealth drops them last minute? Legal mistrial. I don't think that's going to happen. Theoretically, it wouldn't be a mistrial because the prosecutor can absolutely do that in the middle of trial, and no defense is going to be like, no, you have to keep the worst charge there. It's like, no, defense attorneys aren't going to do that. I missed it. When does this start, chat? Sorry, I'm late. So we don't know, either Tuesday or Wednesday, probably looking more like Wednesday for opening statements, hopefully. And also from my perspective with the opening statement, like, even people that hate Karen Reed, hate the way she looks, hate the way she talks, hate the way she's giving interviews, tell me what part of that opening you disagree with, right? And you may give a little more grace to the cops, but they were bad cops in those moments, right? I think we can agree with that. Peter, how much do you think Aunt Bev will limit the ARCA witnesses? I don't know what you mean by limit them. I think she's going to let them testify to everything they need. Now, I don't know if they've asked her again if they can testify to the causation of injuries, because now you don't have to be a medical doctor. So I don't know if they're going to try that again, but that's the only limitation I could really see. And then, of course, she's not going to let them say that they were hired by the feds, even though, of course, they will. Big Apple Hoosier question. Do you think Karen's likability plays a role with the jury? Absolutely. I think it plays a role with every jury, every client, whether it's a criminal defendant, civil plaintiff. It absolutely matters. It absolutely matters. So, Mr. AMG, you have to be careful. You probably have to save that for closing. But I would say in closing, you've got to be sure. You've got to be sure. No maybes, no possibilities, no probably, no filling the holes for the Commonwealth. You can't do that. You can't say, well, you know what could have happened? Karen Reed could have done X, Y, and Z and ended up that. You can't do that. If it didn't come out in evidence, you can't add facts that weren't here. It has to be based on the evidence presented to you. You have to be sure. You have to be sure it wasn't Brian Albert. Sure it wasn't Brian Higgins. Sure it wasn't a dog attack. Sure that he was hit by a car and could even have been hit by a car. And again, you can reference, when you're talking about ARCA, the bad police work by Trooper Paul. You can still reference that their trooper said he did a pirouette and somehow landed there without breaking any bones, but it hit him hard enough to break the skin and shatter the taillight into a million pieces. The evidence will show the investigation sucked. That would actually be compelling to me. I mean, I got to be honest. You got to be careful about what kind of language you use, not to be too much slang. To me, this would depend on my jury, who I picked on the jury. If I thought they would vibe with the investigation sucked, I might say it. If I think they might think that's, too unprofessional, then I might not say it. Can the defense say that the majority of prosecutors would not take this case based on the shoddy evidence? No, they can't say that. They can't say that. Let me see. Netwoman, thank you for gifting. Thank you for everybody that's gifting the memberships during this live. The rural juror. In my opinion, the defense shouldn't have to ask permission for Arca to testify to cause of injury. Bev said herself, this is a new trial with new rules. If Crosby can, logic says there's a new rule in place. So you have to disclose what your expert is going to testify to. So if they want to voir dire on that expertise, they can. So far, they've only focused on the whether or not the accident reconstruction, basically, versus the mechanism or causation for injury. So I think they would have to put the Commonwealth on notice if they plan on doing that. And if the Commonwealth wanted to object, they should have the opportunity to do that. I'll never get over the pirouette. Yeah. I mean, that I would really try to hit all the buzzwords, right? The Proctor texts, destroying a phone on a military base, pirouette, red Solo cup, stop and shop bags. Like, I would try to hit all of the buzzwords that really will shock and awe the jury, that will absolutely come into evidence on that stand. Do you touch on the BAC? So I think I might deal with it in closing, like, and that's the other thing that's hard. They don't really admit that she was drunk. They say maybe she didn't drink all those, but I might say, regardless of how much Karen Reed had to drink or drive, if a car did not hit John O'Keefe and the state cannot prove that to you, then she is not guilty of any of these crimes. They did not charge her with DUI. That is not something you are here to decide. So if you're coming in here and you think she should be convicted of DUI, therefore I'm going to find something to convict her on, that's not how the law is written. You know, you got to be delicate. I'd have to put a lot of thought into the language I would use on how to explain it. But I do think they have to deal with it, because the last jury was basically like drinking, driving, the car was in the yard, the body was in the yard, it must be guilty. Okay, I did that already. Police investigation expert. Anyway, door could be open to allow the defense expert on police investigations in. I don't know. It doesn't seem like it. We'll see. I think if he could have been allowed in, basically his testimony would be my opening statement. Beyond a reasonable doubt versus more likely than not. Yeah, I would absolutely talk about that. Absolutely talk about that. Shoulda, coulda, woulda, maybe, more likely, probably. None of that's good enough. Do you think she'll admit the dog bite guy, Garrett Wing? She hasn't really been striking a lot of experts. So my guess would be yes, unless she finds it to be untimely. Is this a red Solo cup? Yes, it is. It says Solo on it. Don said no mock opening statement, so you must have missed it. It's started about 25 minutes ago, I think. So I don't know how long that was. Maybe what I did was about 15, 20 minutes. So they'll have more time than that to delve into the more specific facts. I always love it when you do this mock opening. Do one for the Commonwealth too, please. Can the Commonwealth object when the defense put up the expert's credentials? I don't know what Judge Cannone is going to allow, but as a demonstrative, I think their credentials should be allowed. And I've done that before. I've read through credentials. I've shown the credentials of the experts in opening. Again, that's going to come out in evidence because I'm going to ask them to testify to it, because I want to give them a lot of weight before I tell the jury what they're going to testify to. So, some cases are literally won in opening statements. It's not supposed to be like that, but sometimes it happens. From my perspective, I mean, I don't want to do the Commonwealth opening now because I didn't plan on it. I don't have it in or clipped out. So maybe we'll do that tomorrow night. Maybe I'll think about it a little bit, what I think the best points are, and maybe we'll do a mock opening for the Commonwealth tomorrow. A side note, when do you think you will do a Lori Vallow breakdown? Do you think you have time to hit Koberger Motions, best channel, best chat? Lori Vallow, I don't know, probably tomorrow. I haven't listened to the whole thing. I only listened to the first half of today. Koberger, I only listened to part of it. I don't know if I'm going to be able to squeeze in a Koberger breakdown. My guess would be probably not. Probably not. So Lady Losandra, I don't agree, Peter. If they can't speak about the feds, then why mention who hired ARCA? We can just agree to disagree on this one. I think it's a very big deal to have somebody do the testing and come up with these opinions that I didn't pay as a lawyer. Because, you know, we're used to every trial, each side being like, those people are hired guns. They're paid to say whatever their lawyers want them to say. I expect the defense to absolutely try to explain that they are hired by a third party. I could be wrong, but that's what I expect because it is important, even if you can't say it was the feds. Now, it would obviously be better to say it was the feds. The rural juror, can the defense point out the Commonwealth theory has changed from Trooper Paul to new action reconstructionist? How can they navigate that? I would ask, if it really is different, I would ask the new expert, do you think this happened? Do you think this happened? Do you think this happened? Do you know whose opinions those are? Trooper Paul. So you can absolutely get those in. Ashley, how do you let the audit report in and not be able to speak about Sandra Birchmore? The audit report's not coming in. Doesn't that open the door to their poor investigation covering cops? The audit report is not going to come in. We did a video on that, why it won't come in, why it can't come in. Do you think the defense will call Trooper Paul? I don't think they need to. I think they can get it in through questioning, really. But maybe they will. Maybe they will. Paid, not hired. So that's an interesting distinction. I wonder if they do have an engagement at this point, if they do have a contract. Because I would not try to do this distinction. I would not try to say, oh, well, we didn't really hire them, or we only paid them for their preparation. Because you paid them to sit in the chair and testify. That's what you paid to do. You paid to fly them here, to sit in that chair and testify. And it is what it is, members of the jury. They're professionals. Thoughts on Corey Richard's case being put on an indefinite hold? It's not that unusual if they do an interlocutory appeal for a certain reason. I don't know. I haven't been fully keeping up with what happened there, but I just know it's an interlocutory appeal, which is not completely abnormal. Followed you well before. I'm assuming you're talking about Donna, because I usually want to say Dana when I see it like that. Pleasantly surprised to see you on her show today. Yes, it was fun. It was fun. Thank you, Azam, for the super sticker. Big Apple Hoosier said, what's a pirouette? It's like what a ballerina does. You know, they do a spin. And he said that John O'Keefe got hit in the arm and did a pirouette with his body. Welcome to Kelly and all the new members joining us tonight. Mr. Meathook, how much emphasis on explaining reasonable doubt to the jury? Hammer for several minutes or sprinkle throughout? I don't know if you mean in the opening, during the trial, or in closing. Hammer it hard all day long in closing. Sprinkle it throughout opening, I would say. But the way I like to do it is I like to reference jury selection, right? Because a lot of times you talk about reasonable doubt and presumption of innocence and how those are core parts of our system. We cannot throw those away. We cannot forget those throughout the trial. And yes, that's technically argument, but a lot of times you're allowed to kind of say that at the beginning of the trial to make sure the jury understands and knows that's where we are right now as we start this case and we start this trial. Netwoman, I've already forgotten a lot of the first trial. I think a lot of people will. Did John have any injuries to his arms, hands that occur when somebody usually braces for a fall? Thank you for so much for doing a late live. You are truly the best. Any chance of doing nighttime lives during the trial? That's the plan, Netwoman. And I'm trying to get back into my fighting shape, you know, kind of like when professional athletes that have to peak at night, like NBA players are notorious for like napping during the day so that their peak performance is late at night when they're playing until like midnight. So I'm trying to get back into that form with tonight's live. Nobody seemed to indicate that any of his injuries looked like he got hit by a car or was bracing, getting hit, falling to the ground. Now, maybe neither side focused on that because under either theory, if there was a fight, if he tripped and fell, or if he was hit by a car, maybe he would have braced himself with his arms or hands. I don't know. It wasn't really a big point of contention in the first trial that I remember. Why is everyone forgetting arms are on a hinge? What is the shoulder? Those injuries just don't make sense. So from my perspective, if you remember Hank Brennan talking about their expert, he says, you know, that's good proof for them that how it was bent, you know, measuring up from the ground, how the cuts were, where the breaks are. From my perspective, I want to see the Commonwealth's expert on that as well. What is Peter going to do when that Adelson starts? I don't think that's going to start until after, like for a while after Karen Reed's trial is long gone, maybe during her third trial. Are you happy about Rory? I'm happy for him. Grand Slam, one of the greatest golfers of my generation. It's always cool to see. Always cool to see. Let's see here. When you do your next video on Lori Vallow, I'm loving how often the prosecutor needs time to go get the witness. Camera focuses on the judge during any downtime. I mean, AO. I did think there was some interesting stuff that happened in the morning today, but I haven't watched the afternoon yet. So I'll get to it. I'll get to it. Matt said, don't flatter yourself. You're not a professional sports player. Thank you, Matt. I needed you to remind me of that. I was starting to think that I was. So I appreciate that. Yeah. I mean, again, and this is the point of when you talk about opening statements and closing arguments, especially in a long trial like this, you're never going to be able to hit everything that's good for you. You're never going to be able to hit everything. So you've got to pick a theme, a theory, highlight the biggest points. And to me, highlight the things you think will absolutely come out exactly the way that you say them. And that will, of course, bring the jury to your side. Like, what jury is going to want to ride with law enforcement like that? Who wants to ride with that team, with that prosecution team? That's what you want to do, in my opinion, and how I look at opening statements. All right. That's all we got tonight. Hopefully you guys enjoyed this. If you did, hit the like button. And if you want anything else like this, let me know. Oh, Brooklyn Basement is here. Long time, Peter and chat. This one's for your objection. Boring the other day. Yay for late night. Thank you, Brooklyn Basement. Peter, where did you get that shirt? This is one of my Greece shirts. Talk about I'm going to Greece for the summer. My wife's buying us like, a whole, new wardrobe for the show or for the trip, it feels like. And this was one of the new shirts that appeared in my closet. So I don't know where I got it, but okay. So yeah, you can let me know. I'm sure there's gonna be some good and some bad and some ugly about the opening statement if you want to. If not, no big deal either. I just like to do it as like a thought exercise. How would you pare it down? What parts would you pick? What parts wouldn't you? Because it's always easy to be like, oh, they suck, or they missed this, or it was boring, or it was too fast, or too long, or too short. So it actually helps, I think, and it helps you put yourself in other people's shoes and maybe give people more grace in understanding how hard it is, right? When you have a case like this, somebody's life on your line, the whole world watching, literally hundreds of thousands, if not millions of people will be watching. From my perspective, it is great for you to put yourself in their shoes. And what would you do if it was an opening statement? What would you say? How would you explain it to them? What do you find most important? To me, that's, I think, a really great just exercise to do in anything. I don't know if this matters with court. We are entering Holy Week. Friday is Good Friday. Do you think trial starts this week? I heard they wanted to start it this week. I think they're not going to have trial on Friday. That's what I would think. But I don't know. I have a red Solo Cup shirt from my colleague Days that I should wear when the trial starts. It's definitely a buzz term for this trial. No doubt about it. Yeah, I mean, the pressure is real for a trial lawyer. You got so many things going on. Sometimes you forget about, this is a speech. All eyes on you. You're up there by yourself. Nobody protecting you. You've got to do it. You've got to drill it into the jury's head while staying within the rules. Incredibly important. Yeah, a lot of times, Ashley, so I'll just tell you, like, a lot of times I have picked a jury in almost a full day, and we'll finish at like 3:00 picking the jury, and we'll just do opening statements before we break for the day. So maybe they'll be able to finish tomorrow. Maybe they'll just do opening statements and break. Maybe they'll wait till Wednesday morning. But I got my fingers crossed that they'll be able to get the last 2 jurors tomorrow, and we'll be done picking this jury Tuesday. Peter, do we watch tomorrow or no? How do we know? My guess is it will be announced on Twitter when they have the jury, and they're going to have to swear them in. They're going to have to read them some jury instructions. It's not like it's going to start immediately. There will be some time period where there will be reports on Twitter. I'll make sure I put it up on my Twitter. Give me a follow at Lawyer and I'll make sure if somebody says, okay, the trial is starting at 2 p.m. or something like that, or trial starting Wednesday, I will retweet that or quote tweet that so you guys can see it. Word on the street is openings 4/22. Ugh. Why would they wait that long? Oh, Tuesday next week, Ashley said. What a break like that. Well, who knows? Maybe we'll have an entire week with no openings and nothing. I guess that makes sense if, we're trying to get through Easter and even the Monday after Easter. I just think that brings in the opportunity to lose more jurors of the group that we already have. But I guess we'll see. Only time will tell. But like I said, I will retweet things on my timeline as much as possible to keep you guys up to date with the schedule. Thanks for, okay, so if you don't do Twitter, then Instagram, I'll try to post it on there as well. But that's all we got. I appreciate you guys so much. Make sure you hit the like button if you have not already. Till next time, I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a uase you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.